Nice to meet you. Sorry I'm running.
We're live.
Good afternoon. It is the 26th of March, 2021. This is the House Judiciary Committee. We have what will be a brief hearing of bills that were cross-filed bills that have passed the Senate and are now in this committee's possession. I believe we have Senator West's aide here today, Mr. Fanto, and he is going to present Senate Bill 494. So we'll give him the floor here so that he can present the bill for Senator West.
Thank you, Chairman Clippinger and members of the committee. I'm pleased to present Senate Bill 494, the Juvenile Restoration Act. This bill is one that you have already heard in the form of the cross-file from Delegate Lewis. There was a full hearing on this back in January. And this bill, the senator basically wants me to emphasize that this bill is not what people are considering a get out of jail free card, but a review of cases in which someone has been deemed able to have a review of their case through certain circumstances. There's a lot that is required of this individual before this hearing can proceed. And the whole emphasis is that this is not a get out of jail free card bill. And so the senator just wanted me to emphasize that. And if you have any questions, I'd be happy to try and answer. Otherwise, defer to the senator.
Right. There is a question from Delegate Griffith.
So I've never experienced this before when bill sponsors aide or staff introduced a bill, and I was hoping to ask this of Senator West, and so unfortunately I got asked this of you. So I apologize for this. Not trying to put you on the spot. But this is a real question and a real concern about this bill. So, as we know, Baltimore County Police Officer Amy Capro, who was killed in the line of duty in 2018, and who was honored just last week by U.S. Senators Ben Cardin and Chris Van Hollen with the Congressional Badge of Bravery, an award from the Department of Justice that recognized exceptional acts of bravery while in the line of duty. So my understanding of this bill is individuals after 20 years can ask for a reduced sentence, and that sentence could be reduced all the way to that moment. So they could apply for a reduced sentence and walk after 20 years. So I guess my question is, would this bill allow Officer Amy Capro's murderer to walk after 20 years?
The case could have an opportunity to be reviewed, but the review would not occur unless certain factors were met. Sure. And something I remember from the floor debate that went on a while in the Senate was that they mentioned the Miller factor of the Supreme Court decision, where there's several hurdles to clear before this hearing can proceed. The most heinous crimes will not clear those hurdles. And in the event of crimes such as this, where it's a terrible crime, there's going to be a lot of things taken into account: victim statements from the family of the victim, or witness statements. There's going to be a lot of things taken into account before a hearing can even proceed.
So you're saying the most heinous crimes will not qualify after 20 years?
If that's what they are, if the burden of proof that the jury or the judge sees is deemed such, if everything's presented and that is not sufficient enough, they won't have the review.
But they could.
They could. But it still has to clear several hurdles, and you'll notice there are very many hurdles mentioned. But
under this bill, Amy Capro's murderer could walk after 20 years.
He wouldn't walk, but there's a potential for a case to be reviewed.
Well, this case to be reduced all the way down.
It wouldn't be a decision. It's just a case review. It's not a reversal of a decision. It's just
but it could be reduced all the way down to that day, time served, and walk, or finish their term at that day.
But whatever I've said is my knowledge as far as I know. I'm happy.
It's not fair to you that you're here instead of the senator.
Yeah.
I apologize for that. This is not.
Oh, of course.
I appreciate it. Thank you.
And Delegate Griffith, we've not had a crossover, or you have not had a crossover like we normally have during the legislative session. And it is not unusual during crossover for delegates and senators to send aides to the other side of the street during the time after crossover, because of the amount that's going on both sides of the street. So I'm not taking anything away from your question. I just, it's not unusual for us to do it this way. You just didn't see it last year because we left early.
Yeah, Mr. Chairman, and I apologize for that. Again, like I said, with the.
Don't apologize. You're fine.
last year, we didn't experience this, so thank you for your
You're fine.
understanding.
No, that's fine. All right. Seeing no further questions, that concludes the hearing on Senate Bill 494. Senator Kelly and Senate Bill 202. Senator Kelly, and something that is also not unusual during crossover, Senator Kelly is not available for us at all. She's chair of the Finance Committee in the Senate. So in your packet, or I think on the floor system, and if it is not there, we will make sure it is there. What Senator Kelly on Senate Bill 202 has asked is for the committee to refer to her written, somebody's, Delegate McComas, you're on, that's fine. Senator Kelly has asked for everyone to refer to her written testimony on Senate Bill 202. Further, however, Senate Bill 202 is different in some ways than the bill as initially introduced. And I'm going to ask council to talk about the differences in the bill from what would have been House Bill 3, something that we passed previously. So Claire, if you wouldn't mind just indicating the difference between what we passed in House Bill 3 and what the Senate passed in Senate Bill 202.
Yes, sir. This is the bill that takes the governor out of the process for parole of people serving a life sentence. And the Senate amendments make two changes. The first one is that they eliminate allowances for diminution credits from the time that an inmate under the bill must serve before being eligible for parole consideration. So in other words, under current law, a person serving a life sentence has to serve 15 years less dim credits to become eligible for parole. The bill as introduced increases that to 20 years less dim credits. And the Senate amendments make it 20 years straight time. You have to serve an actual 20 years before becoming eligible for parole on a life sentence. And the second thing that the Senate amendments do is that they require that inmates serving a life sentence may only be granted parole with the affirmative vote of 6 members of the Parole Commission.
Right. Are there any questions, not necessarily on the larger policy, but any questions on the language of what the Senate passed for council? All right. Again, I asked the committee to read the remarks from Senator Kelly. There was other testimony also offered in writing from people in opposition to the legislation. That is available on should be available on your floor system as well. And with that, that concludes the testimony on Senate Bill 202. Committee, we're going to take a break right now. We will come back. I'm going to just say at 2:30. We will come back at 2:30 for a voting session and go from there. So thank you very much. This has been the bill hearings today for the House Judiciary Committee.